So for our listeners, just a little bit of background on Bill, although I know a lot of you already know who he is. Bill Eddy's a family lawyer, a family therapist, and a family mediator. So he's got lots of expertise packed in there. And he's the Chief Innovative Officer and a founder of the High Conflict Institute. He's the author of 20 books and manuals on high conflict personalities and situations. He's essentially the go-to person in our field for high conflict matters and high conflict personalities. Bill's website, highconflictinstitute.com, is the go-to resource for separating and divorcing couples and parents, and in particular those dealing with high conflict relationships. On that site, you'll find Bill's podcast, which is called It's All Your Fault, and a collection of articles, books, and videos that are rich with strategies and skill-building ideas. So I'm so excited to welcome Bill to the show today.
Thanks so much, Leanne. I'm glad to be on, and I look forward to speaking to you and your listeners.
Well, we're happy to have you here.
So we're going to jump right into some questions. And before we do, Bill, I can't tell you how humbled I am that I am speaking with you. We're in 3 different locations, but you, although are American and often in California, your messages, your education, and your tools reach beyond every border within the world where divorce is affected, which is, in other words, everywhere. And so here in our little country of Canada, we are well aware of Bill Eddy and the tools and the education that you've provided, and we use it all the time. Judges, mediators, lawyers, divorce coaches, and social scientists have all often quoted Bill Eddy. Or to put it another way, what would Bill Eddy do in that situation? So with no further ado, I'm going to roll right into a question.
Sure.
As a family lawyer myself, I get hired quite often. And sometimes people tell me why they are hiring me. Last week, somebody contacted me and said, "Are you Steve Benmor?" I said, "Yes." They said, "Well, I want to hire you. I heard that you're a pit bull, and I want a pit bull as a lawyer to take my wife down." And after he finished, I paused. And I said, "I think you reached the wrong person. I don't provide that service." But then after I finished the phone call with him, I realized that he's just going to shop around and find another person who finally fits that framework. And when I read your material, Bill, on high conflict, part of what you talk about is high conflict lawyers. And they can sometimes be far more problematic than the high conflict spouse. So what do we do with those people that are looking for a pit bull so that next time I get one of those calls, I know what to say to them to potentially change their approach to their divorce?
Well, I really would start in educating them. And I like to educate clients about 3 different types of approaches. So one's the pit bull aggressive approach where the goal is to harm and destroy the other party. The second is a passive approach where you don't confront and you don't look difficult, but you get walked on. The third approach is what I like to do, and that's the assertive approach, where I protect my client, but I don't try to destroy the other person or the other side. And so I like to educate people about those 3 approaches and then suggest that the pit bull style isn't really my style. So if you want to hire me, you're going to get the assertive approach. I'm going to stand up for you, I'm going to work at protecting you, and I'm going to assert my client's needs, but I'm not going to try to destroy the other party. And in fact, I want to get the other party to work with you so we can resolve some things out of court and save for court what really has to be decided by a judge. And sometimes nothing has to be, and sometimes everything has to be. So what you get with me is an assertive approach, not the aggressive pit bull approach. So the last phrase, and I always recommend that lawyers, professionals, family members say this, and that is, "So it's up to you." Because that way I'm not telling them goodbye, because maybe they'll go, oh, well, I want to work with you, so maybe I'll work with your way. And other times it's, no, I want to destroy my wife, and I'll say, that's not my style.
Great advice. So the next question that we have for you is a situation that, I've had come up many times with clients. So I'm really interested to hear how you would, or what your recommendations are on dealing with this type of situation. But, so I have a client who says, I will not communicate, with my spouse. Every time I do, he or she is abusive or vindictive. And so I want all communication to go through lawyers. I don't care what it costs. That's what I want to have done. How should a lawyer deal with that type of client?
Well, I think I'd want to find out more just to understand, what are you facing? Because in the extreme, sometimes I do recommend that approach, but it's only in the extreme. And so I'd want to know, is this the beginning? Is this where the client wants to start? And is this client someone who I can teach, our BIF email method to, and who may learn how to set limits themselves and what to ignore and what to respond to. So I'd want to know more about the client and more about who they're dealing with. And again, I would educate them about options and then say, it's up to you. Now, you may decide that you don't want that kind of a case because that's so labor intensive. Or you may decide, I'm willing to do that in this case, but the client needs to understand this is going to be, my retainer is at least going to double to manage this, because we don't have control over the other side. And so the other side may drive your fees up, and I hate to say it, but I have to charge for my time. And so give them those choices. Say, given that that's the situation, I'll do it, but it's up to you. But if you won't do it, and it's reasonable to say, I'm not, I have other cases, I can't be that labor intensive on this one case. And so you'll need to find somebody else for that. So it's really, it's up to you, and then tell them it's up to them if you are open to that.
Makes sense.
Thank you, Bill. One of the things that has made you so popular is you've taken something as complex as communication, post-separation, and you provided the world and us lawyers and mediators with the BIF tool, the brief, information, firm, and friendly approach. And I, by the way, am a very large proponent and circulator of that approach. But I've had some clients say, that's all fine and well, but we've been fighting for years. We've been fighting for years before we split up, and we just turned our fighting into fighting in text messages and emails now. And you're trying to convince me to start using a new language. And when my husband uses dirty words on me and I use BIF on him, well, it's almost like we're speaking two very different languages. So how can you convince me, Mr. Benmor, to use Mr. Eddy's BIF approach when my spouse or ex-spouse is speaking a foreign language? So what do you say to that?
Yeah, no, I'd say there's several reasons to give this a try. And I always say you might be right. Maybe you have a situation where this just won't work for you. But I would suggest that we have taught through our books, seminars, coaching, and trainers and other people we speak with, we've taught about 1 million people this method. And we constantly get feedback that people feel good about their BIF emails and texts. So here's why you want to give it a try. Is first of all, it'll take less energy out of you because you're keeping it brief, 4, 5, 6, 7 sentences, just a paragraph. And that saves agonizing over writing a 5-page response to a 5-page diatribe that your ex has just sent you. So you want to just do a paragraph in response to that. This isn't a legal document. If it's a legal document, work with your lawyer what you need to deal with or what not, like with Steve. So it'll save you stress. But here's a second surprising thing. We've found that it looks better to be associated with BIF emails and texts in court than it does to be associated with the horrible language and the terrible words. So if you want to look like the reasonable person in court, write like this. And I know what I'm talking about because I've been on panels with judges at trainings for lawyers and judges, and I've had judges who read out an email conversation, and each person is saying how the other will look really bad to the court. And the judge is like, these are two twins arguing with each other. And so you don't look good when you argue with someone who's not looking good. You don't look good too. And that's where BIF pulls you out of the argument. The third thing is sometimes we get feedback that after a few months of writing in the BIF format, that the other person starts writing back that way because they realize you look better and your writing looks better. And they start copying that, and they don't even know it's a method. And they start writing more briefly, informative, friendly, and firm. So there's at least 3 reasons to give it a try, but, you know, if it doesn't work, it's up to you.
You know, just by way of follow-up, one judge I know, she told me that when she sees affidavits and they refer to emails, that's one of the first places that she goes to take the temperature on the case. She wants to see the unvarnished, unpolished, non-lawyer edited version of communication between these two people to ascertain who is she going to assign more time the child with based on how pleasant or mean-spirited their communications are, because they're indicators.
Absolutely. And something to keep in mind is that people that talk like this to their co-parent may also be talking like this to their children. And judges are very concerned about that.
Mm-hmm.
On the topic of BIF as well, I was actually practicing it this afternoon. I received a very unpleasant email from a self-represented opposing party. And, you know, my initial reaction was to want to be, you know, rude back because this message was so incredibly rude to me. But I thought, nope, BIF, I'm going to keep that in mind in my response. And I think my response was much better because of that. In terms
Leanne,
of
if I may, just before you go to the next question, I'm going to float something by you, Bill, and tell me what you think about this. So Leanne gets this really mean message today by somebody who obviously has an inclination to write that. And so they really probably did not think that message was inappropriate. They probably thought that was the way we communicate. And so if Leanne were to write back something to the effect of, "Dear so-and-so, rather than engage with you and raise the temperature, I will be using a tool provided by this wonderful professional named Bill Eddy called BIF. And here's the article that describes BIF. And now I'm going to use that tool in how I respond to you." Is that a little too in your face, or is that a good way of educating the person on the new style?
It depends totally on the word you use in doing that. Because if you slip into what we call an admonishment, we try to avoid admonishments in BIF responses because they offend the other person and they feel like you're putting them down. So if you've got like some snarky admonishment in there, you know, let me show you how you're supposed to do it, it's going to backfire. Mm-hmm. If on the other hand, you say, you know, I can understand you're frustrated and that this seems like the way to write, but I've learned it's more effective to write using this BIF method, and here's an article attached. It's up to you, but you could explain that. Yeah, as long as it's really just straight information and the tone of it isn't snarky or admonishing.
That makes sense. Now, as family lawyers, we've all dealt with those opposing counsel who, come with these aggressive emails or letters, often delivered, on a Friday afternoon with self-imposed, fake deadlines, that they need a response by such and such a date, and they don't even necessarily say or what's going to happen, but it's enough. It certainly gets a client upset, and if somebody's self-represented and they're getting messages like that from the opposing counsel, it can be upsetting. How do we deal with an opposing counsel who's like that?
So I would reply something like this. Thank you for letting me know the issue you'd like me to address. Unfortunately, I don't have time to do that before next Tuesday, and so I'll be getting back to you then. Have a nice weekend. And that's a bit. That's like 4 sentences, because somebody else's lack of planning does not create my crisis. And I don't remember where I learned that, maybe a school teacher years ago. But we get that in the family law business, people making unreasonable demands, and opposing counsel is some of the culprits sometimes. And I think we need to just pleasantly say, I can't do that. And unless there's some consequence about, like they say, well, I'll be going to court, first thing Monday morning if I don't have that, asking for some kind of relief. But even in that case, you want to be able to show how you responded reasonably and give a realistic response time. So one of the parts of BIF is that it's friendly. So you start out with, thank you for letting me know your concern or the issue you'd like me to address. And I won't be able to do that until such and such. And, have a good weekend. As long as, be very careful not to slip in little snarky comments, because it's easy to do that. And I have to tell you, once I showed something I was going to send to another lawyer who bothered me, and I had my client review it to make sure I covered the issues that we needed. And he said, hey, Bill, there's a sentence in there that if I wrote, you would tell me to take it out. I don't know if you realize, but you may want to take that out. And I looked it over, and I had that snarky sentence in there. And my client was the one that helped me catch that and pull that out. And then it went out as a clean BIF communication.
And
it reminds me
it
reminds me of the saying, kill them with kindness. Sometimes when you're friendly and polite and firm, people don't even know how to react to that sometimes.
Yeah.
And what do you say, Bill, to the client that read your response to the hostile communication, and the client says, well, you're so nice and they're so mean, and you're no competition for them. And maybe I need to move over to a lawyer that's just as mean as my spouse's lawyer. What do you say to that client?
Well, again, I start with education, and I say I found this to be a really well-respected method by judges. So if we end up in court and this ends up in court, your side's going to be well-respected. And I find that it just brings a little peace to the situation rather than escalating this difficult person on the other side, who I agree is quite difficult and quite rude in how they're communicating. But in terms of what kind of lawyer you'd like, this is how I work. This is my style. And once again, it's up to you. So that way I don't trap them, or I don't just respond this way or that way. I say, this is what I do, but you always have a choice. If you want to change to another lawyer, I'll help communicate and pass records. And I've had clients occasionally threaten to fire me, and I'll say, that's fine. I've got a form for that. Should I get it out of my drawer? And they go, oh, no, I'm going to give you another chance, Bill. And I go, okay, just remember, if things get too difficult, either one of us can say goodbye. So let's try to work together well here, okay?
Great. Now, hostile characters, I don't believe, fall into the DSM-5 diagnostic manual. Not yet, anyway. But let's be frank. There's always a person behind the hostile personality. And so when we as lawyers have been in this business so long, we've seen some signs of behaviors that we just know it's not appropriate. It's maybe even not quote unquote normal. But we're not social workers. We're not psychologists. We're not psychiatrists. We cannot evaluate a person's mood disorder or personality disorder, but we get a flavor and we get a feel for there's something more here. And it's obviously creating a disconnect. They seem prone to conflict. They seem prone to hostile behavior, either to us, our staff, or their spouse. Is it simply wrong to try to educate them or to suggest to them that they might need professional help? Like, what do you do with what causes you to really be troubled by something far larger than a really mean email, something that's pervasive and chronic?
Yeah. So this is a very, very tricky situation because you may be talking about someone with a personality disorder, because people with personality disorders have narrow, rigid range of behavior and they misapply it to all situations. And so hostility may be one of those repeating behaviors, but other things going on. So there's a couple approaches. One is, I find it just helpful to think that the person may have a high conflict personality. And whether they have a personality disorder or not, it's not a diagnosis, it's a description of behavior. Preoccupied with blaming others, all or nothing thinking, unmanaged emotions, extreme behavior. So if they have that, or you think they have that, then how you relate to them, you want to adapt. And so you're going to try not to give them insight. And this is all your listeners can apply this to anybody they think might be difficult. Don't try to give them insight into themselves. That really does backfire. If they're like this, they're not going to hear it and they're going to get more upset. Don't emphasize the past. Look at our choices now. And you can tell from everything I've been saying today is educate people about their choices. So even if you're a family member or a co-parent, is say, you know, as I see it, we have two choices. It's up to you. If the two choices are you're willing to give up to them. The third thing is, so not focusing on the past. Third is not engaging real emotionally. Try to be calm, matter of fact, because your emotional upset energizes a high conflict person. They go, oh, now I've got you on the defensive. Now you're upset. I'm really powerful. And you don't want to give them the power to make you upset. So even if you're upset inside, don't show it on the outside if you can help it, and save talking about that for somebody else. But the last thing is, don't say or suggest that they have a personality disorder or high conflict personality. They're so defensive that this will push things over the top. With that said, if you have a client you're concerned about or somebody else, you might suggest that it would be helpful to reduce the stress of the situation to meet with a counselor. And that's what I've done with people who I think maybe even have personality disorders. They're reacting to everything. They're highly anxious. And so I'll suggest, you know, you may want to meet with a counselor to deal with this stress, because this is such a stressful situation. That way I'm not making it about them. I'm making it about the situation. But to be honest, if they're a high conflict person, they never go to counseling, at least not voluntarily.
Is it wrong for us as practitioners to think that we could actually improve their future behavior with others through the work that we as family lawyers and mediators do with them? Or is it really just getting them to settlement and then closing the file?
What I think is teach them some skills like BIF, like developing proposals, like giving themselves an encouraging statement to calm down. These are all skills we teach in our New Ways for Families method, which I encourage people to have their clients and the other side take, even if it takes a court order. So they can learn these skills without ever looking at themselves. And yet, when they learn these skills, they start to behave a little bit better because they go, oh, I should have sent a BIF response instead of that nasty gram I just sent. And so you can't get them to evaluate themselves. On the other hand, if you want just to test the waters, you might say, you know, there's some things you're doing that seem to backfire for you. Do you want to learn some better ways? And if they're a high conflict person, they'll immediately be angry with you for suggesting that they have a problem. And you'll know, okay, sorry about that. And you'll know going forward, don't ever make it about them, but you can make it about learning skills. So that's just if you're not sure. But in general, yes, focus on teaching them skills, focus on getting the case resolved, whether it's by agreement or going to court if necessary, and have the goal being helping them finish and be able to close your case. So in many ways, you're not going to change a high conflict person, but you may be able to help them end up with a reasonable settlement or a decent court outcome.
This kind of falls in with what you were just talking about, and it was a follow-up question that one of our listeners posted that I think is a really good question, which is how do you walk that line between, if you have a high conflict client, how do you walk that line between effectively representing them versus enabling them in their behavior?
I think the key is what I'm willing to do and what I'm not willing to do. And if they want to work with me, this is how I work. And so if they aren't willing to, if they're upset and keep being upset with how I'm approaching the case, they may be better off, or I shouldn't say better off, because I don't think they'll be better off with somebody who does more of what they want, especially if it's unreasonable. But they'll, you know, it's let them know your own boundaries. So much of dealing with high conflict people as clients, as opposing parties, as opposing counsel is setting limits. And so saying, here's a choice, I'll do this, I won't do that, it's up to you. And my experience is most of the time, the more you've worked with them, the more they'll accept working with how you work, because they've gotten to know you and they're already engaged in their case. And you can say, this is what I do, and this works a lot. So if you get me, you get the way I work as well.
That makes sense.
I really like this phraseology that you've shared with us called, quote, it's up to you. By the way, maybe consider writing a book on that with that name of the book's title. But I have a question.
Let me just briefly tell you, one other person suggested that a couple of years ago, and they were in Toronto. Oh. So one of these days I'll write that.
So on the subject of it's up to you, I know that you're way too smart and too intuitive to know that it's not just a phrase. Am I guessing that when you give a client the impression that it's up to them, you are in effect engaging them in the self-determination of their case, and you are empowering them to make the right choices by saying it's up to you after you've delivered a couple options to them?
Yes, and one thing that's important to know is it's fine to advise them, I think you should do choice A. I really do, and I think you'd be much better off in the long run. But choice B does exist, and I'm willing to do choice B if that's what you pick, and only say that if you're willing to do it. I think choice A would be better, but it's up to you. And so it's fine to give them your advice. Everything I'm saying doesn't stop a lawyer from giving their advice. It's just how you do it. That's the key.
Now, I deal with a lot of clients who are victims of domestic violence. And so one of the scenarios we wanted to pose to you is if, say I have a client who's come through the door and she discloses to me that she's been physically abused by her partner. And she says that she hasn't told anybody this before. I'm the first person she's disclosing this to, but that she doesn't want that to form part of any of my correspondence or anything that gets filed with the court or any material because she's concerned that it will make her come across as weak. How should I deal with that type of situation?
The first and most fundamental thing is I think you have to respect her wishes. And especially someone who's a victim of domestic violence is used to not having their wishes respected. Mm-hmm. And we use the term now more and more coercive control. It isn't just the physical violence, it's the psychological manipulation and such that goes with it. So I think as lawyers, we have to say, I respect your wishes. Now, let me give you some information and educate your client. And over the course of a case, let's say it's 6 months or a year, you may point out the benefit and the options for getting some help and how bringing this up to the court may actually help you get more protection in the long run. But it always has to, and this really fits in what Steve was just saying, is the up to you part. What we do, we still, and especially victim survivors of domestic violence, need to feel like it's up to them. So I would start by respecting that, but then educate as much as possible.
Great advice.
So you talk about high conflict spouses, high conflict lawyers. As crazy as it is, and very few of them exist, but there are some high conflict judges too. We all have appeared before judges that maybe they don't want to be doing that job anymore, or maybe they're just jaded because they've been at it for so long and they've spent so many years hearing conflict and hearing parents bickering. But is the advice that you give and the steps that you give and the tools that you give, would you say it's equally applicable irrespective of the recipient, spouse, lawyer, judge, or does it differ? And you never want to come off as being condescending to anybody, but definitely not condescending to a judge.
Right.
What do you think about that, Bill?
Well, I think, first of all, one general principle I've learned about high conflict people and high conflict personalities is how to deal with them goes with the personality, not the position they're in. So you may have a lawyer, you may have a therapist, you may have an accountant, you may have a judge, you may have a police officer, you may have a fireman, you may have a plumber. It could be anybody. And if you realize they have that pattern, then don't try for insight and those 4 things I talked about. Insight, focus on the past, try to de-emphasize that, avoid emotions, and don't label them. So with judges, I think the thing is to be respectful. Don't use the phrase, with all due respect, Your Honor. They are tired of hearing that phrase. But I think you can say, I respect the court's concern about something. And I think you can talk about the choices that you see that we're facing now. Your Honor, if we, I think of a judge who wanted to try an issue that clearly wasn't ready to be tried by either side at a short hearing that it's like, oh my goodness, we're not prepared. And this was a judge sitting in, says, no, we're going to try this issue. I'm trying to clear my caseload here. And it was like, Your Honor, neither side's prepared to do that. The choices, as I see it, if we do it now, it will be incomplete and you won't have enough information to make a good decision. If we can do this in a couple weeks or even a week, then you'll be able to make a much better decision. So I think talk about choices, talk about how they benefit the court, talk about how they save the court time. And of course, if need be, appealing a case. I only ended up appealing 2 cases out of my 15 years representing clients in family court, and I won reversals in both of them. One case was a partial reversal, but just make sure you get your objections in and that you have a good record so that you can proceed. I want to add one more comment. I was giving a seminar once at a state bar association in the U.S., and a woman in the second row said, "How do you deal with the high conflict lawyers?" And this was many years ago, before that got asked very often. And before I could answer, someone in the back said, "And what about the high conflict judges?" So I said what I'm going to say now, and that is lawyers are in a naturally adversarial position. And so we tend to see a fair percent who can't stop themselves. Maybe it's 10%, maybe it's 15%. But I said, but judges are in a position of having to balance things, having to apply the law in an objective, neutral way. And so I don't see as many high conflict judges. We may be talking maybe 4 or 5% at the most. Well, after that session, I was told that the woman who asked me about the high conflict lawyers was an associate justice on the state Supreme Court. and they said, and I gave the right answer. But they do exist, and that's what you need to do.
No, it's a good point that it's not based on their station in life or their vocation or their occupation. It's a description of one's personality or one's behavioral patterns as opposed to their employment per se.
Yeah, and I want to add that your listeners who have supervisors who may be high conflict, etc., you can do this even with someone who's over you, and that is talk about choices, give them respect, and think if there's things you have to set limits. You've just given me 3 projects. I can only work on 1 this week. Which would be your top priority? Things like that. Because they're everywhere at all levels of society. And unfortunately, they may be increasing, and so people need skills. And I want to make sure I can put in a plug for our New Ways for Families method of skills training. We have an online course which anyone in the world can take, and we encourage judges to order it, although Ontario doesn't like to order people to do things like that. And we also have coaches with our online program that do 3 or 6 coaching sessions. And I've trained many coaches in Ontario. So you may find people listening may be interested. And anyone from anywhere in the world. We've been training coaches far and wide. We've got some in Scotland. We've got some in Australia. Many in Canada and the United States. So skills is the focus more than anything that we think will help people for the future.
It's funny you say that.
I was going to say, people go to your website, the highconflictinstitute.com. They'll be able to find that information if they're interested in it.
Yeah, so look for New Ways for Families. And
New Ways for Families.
Yeah, that's the method. And come to our website. I don't know if I've confused things, but we have a second website called conflictplaybook.com, and it's also there, the online parenting class. And we have people in Canada, we have it in Canadian dollars. I think it's $67 for 12 hours of skills training online. So it's a bargain you can't beat, really.
Well, you have a testimonial. Sorry, go ahead.
Leanne and I are very big promoters of divorce coaching. Before Leanne went full throttle into family law representation, she herself was doing a lot of divorce coaching, and I myself refer clients regularly to divorce coaches. And we just had one of the more renowned coaches in Ontario, a woman by the name of Jennifer Aternino Donison, who runs a program for clients, and she herself is a divorce coach, and she wrote It's an amazing program. She's referring, of course, Bill, to your program. And so I'm so glad to hear that you're doing more work coaching people, or excuse me, educating divorce coaches, because in my line of work, I actually benefit significantly when clients of mine go and listen to my advice by hiring a divorce coach in order to help them through the process, because so many of the tools that you give is really the tools that divorce coaches are oftentimes giving clients and educating them, and then of course working with them through the journey to keep implementing those tools, because it's not just educating them once. You have to keep on at them until it becomes second nature.
Absolutely. Well, I'm glad to hear that. Yeah. And I think it really, in a way, it takes a team, and a coach can be a big part of a team approach.
So, Bill, what is it that us and the viewers can cause to make you move to Toronto, Canada, and be a resource to us every week, and to provide mediation services and education to our lawyers, judges, and mediators?
Well, that's why they invented Zoom. Yes, so it's much easier. But I love Toronto. I come up there. I've been in some of your other cities. I've been to Hamilton, Mississauga. I've been to Guelph as well as Ottawa. So you've got a beautiful province up there. But I think you folks are doing a great job at educating people there too. So I want to thank you for letting me be part of your educational process.
Well, on behalf of Leanne and I and all our viewers, some of whom are professionals and some of whom are people who themselves are going right now through separation and divorce, on behalf of all of us and behalf of all of the divorce professionals in Ontario and in Canada, we have benefited tremendously from Bill Eddy and his education and his tools and his books and his programs. And we are so grateful that you were accepted our invitation to share your wisdom with us today. And we will continue using it, applying it, and referring back to you. So thank you very much, Bill Eddy.
Thank
you so much. Thank you so much, Steve and Leanne. It's been my pleasure.
And we're honored that I was going to say, we're honored that you did your first Instagram Live with us.
Yep, this is my very first experience with that. And thank you for tutoring me to get on to making this actually work.
You'll reach more people this way, Bill.
There you go.
All right. Thank you, everybody. And for those listeners, we'll see you next week with another episode of Divorce Explained with Leanne Townsend and myself, Steve Benmor. So thank you, everybody, and have a nice day.
Thank you, everyone.